I'm going to talk to you about post-termination restrictions. I had intended to talk to you about developments in the case law, but typically, having chosen that as a topic some months ago, the last 12 months have been about as quiet as it's possible for it to be on the case law front. So instead, what I propose to do is to provide some practical hints and tips about how to deal with what is an all too common situation where a senior employee with a contract that contains post-termination restrictions sends an email saying they're going to leave and take up a role with a competitor. So the first thing is the need for cool heads, because the temptation for any employer faced with the unexpected departure of a senior employee is to fear that the entire edifice of their business is about to come crashing down around their ears. And the reality, as we as lawyers all know, is that that's very rarely the case. Even the most effective and highly paid employees are ultimately replaceable, and the departures of these employees often give opportunities for more junior members of staff to step up and take their place. On a similar note, there's a temptation in particular where the employee is in sales to fear that all of the business's clients are going to follow that employee out the door into her new role. Again, rarely the case in practice. And as an advisor, I think our role as lawyers is to encourage business owners to have a bit more faith in the quality of their business and their brand. One thing that is quite useful to do when you get the dreaded email is to consider the reasons for the resignation. Not just those that appear in the body of the email itself, but also any underlying issues that might explain what would otherwise be an unexpected resignation. Is it simply about money? Are there other issues in the workplace that this brings up that the employer wasn't aware of and need dealing with? If, and only if, I would suggest, an employer understands why a senior employee has decided to resign, can they start to take steps to either persuade the employee to stay, if that's what they decide to do, and probably more importantly, better protect themselves against the possibility of the same thing repeating months or down the years with someone else. So the best advice, in most cases, is to take some time with a cool head to consider the implications of the departure and the reasons for it. In my experience, and I'm sure in yours, employers, particularly owner-managed SMEs, tend to take these sort of things as a personal slight and allow emotion to dictate their strategy. It's our job, I think, as lawyers to take that emotion out of the conversation and to give calm and dispassionate advice. And one of the reasons that calm and dispassionate advice is so important is because it informs the nature and the tone of the communication with the employee and with their proposed new employer. Sounds obvious, I know, but the tone of your communication with your employee who's departing or proposing to depart will be very different if your strategy is to try and persuade them to stay, as compared with the situation that you accept that they're going and you're going all out to protect your business interest. Next, the big decision. Do we litigate? Do we take this to court? And another reason that a period of calm reflection is important is because it assists in informing that very serious decision, whether to commence proceedings seeking an injunction. And there are a number of factors that go into the mix when that decision's being made, and we'll go through them in a moment. But one factor that should never, ever inform the decision whether to litigate is emotion. Litigation is a tool which is available to an employer to allow it to realize its business interests. It is no more and no less than that. It should always, in my view, be a tool of last resort, because there are a significant number of disadvantages to commencing proceedings for an injunction. There are some advantages. Obtaining an injunction to restrain an employee's proposed breach of their post-termination restrictions is a fantastic piece of business protection. It's very effective. It also, and this is a consideration for some employers, draws a line in the sand and shows that the employer isn't going to put up with this type of behaviour to encourage the others. Both of those are perfectly sensible and good reasons for taking the step of issuing proceedings for an injunction. But there are also very good reasons against litigation. One of them is the commitment that an employer has to make to substantive proceedings. I've lost count of the number of employers who think that if you want to get an injunction to restrain a breach of post-termination restrictions, you just go to court, get your injunction, and that's the end of it. It's not. An injunction is simply an interim remedy on the road to substantive relief, which is given at the end of a trial. So by issuing proceedings with the aim of obtaining an interim injunction, an employer is committing itself to what's likely to be 12 to 18 months of litigation, unless it's possible to settle the case in the meantime. You've got to issue a claim form, you've got to draft particulars of claim, and you've got to commit to the vast expense and time commitment of litigation as a whole. I often describe litigation to my lay clients as a bit like rolling a snowball down from the top of a hill. You can choose whether to start the process, but once you've started it, you immediately lose control. The loss of control isn't total, of course. A claimant can always discontinue a claim, but the loss of control is very significant nevertheless. Expense. Litigation is very expensive. That should be something that you are telling your clients right at the start. Employers, in my experience, often fail to recognize the very significant amount of work that you have to do to get a claim and an injunction application off the ground, particularly because it involves working to an exceptionally challenging timetable. What do I mean by that? Well, it means everything has to be done pretty much overnight. It's work intensive, and that means it's expensive. Whereas encouraging the others is a very good reason for taking out proceedings to get an injunction to restrain post-termination restrictions, it's only a good idea if you win. And one of the risks of injunction proceedings is that you lose. And losing injunction proceedings sets precisely the opposite precedent to encouraging the others. It sets a precedent that you don't know what you're doing and you can't protect your business when employees want to leave. Publicity depends on your employer, but publicity is often a negative factor that militates against the decision whether to litigate. Court proceedings are conducted in public. Witness statements deployed in those proceedings are available to be inspected by the public and the press. Applications for injunctions to restrain post-termination restrictions almost always involve potentially commercially sensitive or reputationally damaging material. There's a reason people fall out and want to leave, and it's normally not the sort of reason that you want published in the press. So employers need to think very, very carefully about the consequences of placing their internal disputes voluntarily into the public domain. So deciding whether to litigate is a big decision. As you'll probably have guessed from what I've just said, it has to be a really, really important case for the employer to justify the decision to litigate. In many, many cases, once that initial emotional reaction has been taken out, the sensible business decision is to try and resolve the dispute without going to court. But we've made our decision. Our clients decided that they want to protect the business. They want to draw their line in the sand. What's the best way to make sure that we get the injunction that we're seeking? Well, the first question is to limit the relief sought. So less is more in injunction applications. The less you ask for, the more likely you are to get it. What form of injunction do you want is an important question, because most professionally drafted contracts of employment nowadays will have a full suite of restrictions which purport to bind the employee post-termination. it is by no means essential, and indeed I would say it is inadvisable, to seek to enforce all of them in your proceeding. And the starting point must be to ask the question, what harm am I seeking to prevent here? So if, for example, you've got a non-solicitation of current employees covenant, but you don't think that your departing employee has any chance of poaching your staff, why ask the court to enforce that covenant? The danger in seeking to enforce everything, where you only need to enforce something, is that it gives the impression of overkill. And a factor that employers have to grapple with when they come to take these sort of proceedings out is the judicial tendency to take the view that a well-resourced, deep-pocketed employer is seeking to crush the poor employee. Injunctions are ultimately discretionary remedies. And never forget that litigation is as much about the battle for the hearts and minds of the tribunal that you're appearing in front of as it is about brilliant technical legal analysis. Very often, a principal concern will be to restrain the misuse of the business's confidential information. Most modern contracts of employment will have confidentiality clauses which purport to bind the employee post-termination, but even if you don't have that, the common law will provide you with an extra contractual remedy in the form of an action either for breach of contract, relying on an implied term, or for breach of confidence. And in my experience, judges are much more amenable to applications brought to restrain the misuse of confidential information by a departing employee than they are to restrain other post-termination restrictions such as non-dealing, non-solicitation. And that's because, in relation to misuse of confidential information, the restrictions that you are seeking to enforce do not involve restraint of trade issues. Where an applicant for an injunction to restrain the use of confidential information, while they must be careful to properly limit and particularize the information which they say is confidential, except in a very rare case where there's a genuine dispute about whether that information is in fact confidential, it's in fact very difficult for a defendant to articulate a proper ground for not giving an undertaking or submitting to an injunction. In what circumstances can a defendant legitimately say, I should be allowed to use my employer's confidential information? Not many, I would suggest. So, for a savvy employer who doesn't have a very well-drafted contract of employment, or has a very well-drafted contract of employment with lots of covenants in, but they're very wide and unlikely to be enforceable, or an employer who's worried about facing an allegation of constructive dismissal by the departing employer, by the departing employee, which is an issue we'll come to, that employer might well look to a misuse of confidential information injunction as a way of maintaining some control over their departing employee. And indeed, in some cases, judges have been willing to grant non-deal, non-compete, non-solicit covenants where they otherwise wouldn't, because it said that those covenants are necessary to police the misuse of confidential information. So confidential information injunctions are a very useful tool in the litigator's armoury. Your client will want to know if their covenant will be upheld. Not always easy advice to give if you were the person who's drafted the covenant for them, but one factor that obviously has to be taken into account is an assessment of whether the court will uphold the covenant as a reasonable restraint of trade. That is far from the only issue, as I hope I've demonstrated. It's only one factor among many. So there are, for everyone in the room, the familiar principles upon which the court decides these things, set out in bullet points. Covenants in restraint of trade are unenforceable except to the extent that they protect a legitimate interest. The categories of legitimate interest are well established and limited. and if the effect of the covenant is to go further than is reasonably necessary to protect that legitimate interest, it will be enforceable. That's your law. One point that is worth emphasising, though, is that the court might apply a different test depending on what stage of proceedings you're at. So on an application for an interim injunction, where the trial of the action is likely to be heard before the restriction expires, the court will apply the usual test for interim injunctions. That's set out in American Cyanamid. Is there a serious issue to be tried? And if so, where does the balance of convenience lie? Most restrictive covenants, most post-termination restrictions, unless they are very poorly drafted, ought to meet that test of whether they raise a serious issue to be tried. So unless you've got one of those really wide and obviously unenforceable covenants, or you've got issues about constructive dismissal, the chances are that on an interim injunction application, the battleground is going to be balance of convenience. Balance of convenience brings a multitude of factors into play, but invariably one of them is the extent to which the employee who you're seeking to restrain will be unable to earn a living pending trial. So in many cases that I've dealt with, the decisive factor in an otherwise evenly balanced case is the fact that the trial won't get on for 4 months, and during that time, if the injunction is granted, the employee, their husband, and their children will not have a wage with which to live, and that can be a powerful factor. If the covenant's going to expire before any trial comes on, the court will take a closer look at enforceability. So it's not serious issue to be tried in that case. The court looks much more closely at questions of enforceability. It's not quite the same approach it's taken at a final hearing, but it's pretty close to it, and that's the Lansing-Linder test. Obviously, when you're at trial, the only question for the court on enforceability is the covenant enforceable? A point about repudiatory breach, constructive dismissal. An issue that is regularly raised by employees who wish to avoid being bound by their post-termination restrictions is that their resignation came about as a response to their employer's repudiatory breach of contract. If that allegation is made out on the facts, the legal effect of that is that the covenants, no matter how reasonable they are, simply don't bite. This is an important practical point, and in my experience, it is not often understood by business owners. An employer can have the most effective, best drafted, most tightly framed restrictive covenants there are, but if it's constructively dismissed, it's a departing employee, they are essentially worthless. So it's absolutely essential, before the decision is taken to litigate, to investigate the extent to which an employee may be able to argue constructive dismissal and to address the merits of that case. So several practical issues arise when an employer is faced with the decision whether to go to law to enforce post-termination restrictions. What I hope I've got across is that the likelihood that the court will uphold the covenant, the legal question, is only one, and almost certainly not the most important question that your clients have to consider whether they're deciding to go to court. The key advice, though, is when you're asked to advise in what are always, by the very nature of the dispute, fraught circumstances, a cool head and a calm and dispassionate analysis of the commercial merits and demerits of the litigation process should always be at the forefront of your minds.